The three-day Supreme Court's battle to determine the legality of the presidential election results declared by the Independent Electoral and Boundaries Commission Chairman Wafula Chebukati saw top lawyers in the country battle it out in the election petition filed by Azimio Umoja One Kenya Alliance presidential candidates Raila Odinga and his running mate Martha Karua. Senior Counsels James Orengo, Muite, Mwangi and Otiende Amollo, representing the petitioners, asked the Supreme Court judges to invalidate the election of President-elect Dr.William Ruto, arguing no candidate garnered 50+1% of the vote as stipulated by the Constitution for a presidential election win. On the other hand, Senior Counsels Professor Githu Muigai, Professor Kindiki, Kithure, Ngatia and Kamau Karori, representing respondents, urging the Supreme Court to dismiss the presidential petition, terming it fictional as it lacked proof to demonstrate the election that was bungled. Chumba takes us through the arguments.
On the first day of the Supreme Court hearing, lawyers representing the first petitioner Raila Odinga took to the floor to dislodge the election of Dr. William Ruto as the president-elect. The first submission coming from Senior Counsel James Orengo.
There was a systematic deduction of the votes cast for the first petitioner, and the same number of votes that were deducted from the petitioner were added to the votes of the second respondent.
Allocated 3 hours to make their oral submissions, lawyers representing Raila Odinga and Martha Karua told the Supreme Court judges that the presidential election results should be nullified, as no candidate garnered 50+1% of the vote as stipulated by the Constitution for a presidential election win.
We were told the foreigners left before the 8th of August. We were told they did not even have access to maintain the server. This is on the 9th of August, and at the top left-hand corner there is the name of one of the Venezuelans, Jose Camargo. This is the person who decided the president-elect of the country. This person is the one who was interfering with the forms.
Mr. Chebukati, doing these duties and not doing these duties as part of the commission, but by himself.
Then I implore this court to use the same reasoning and tell the chairman in the same voice that it has told the national executive that your power to declare does not give you any power to decide on what you declare.
Petitioner John Njoroge Kamau was the second petitioner to challenge Dr. William Ruto's win during the August general election. Represented by lawyer Zerabanu Jan Mohammed, Kamau asked the Supreme Court to nullify the election on grounds that the Kenyan voter was largely disenfranchised and that the Independent Electoral and Boundaries Commission acted unconstitutionally.
The court's hands are not shackled by procedural niceties. Please, Madam Chief Justice and honorable judges of this court, bite and bite for the glory of this court.
Lawyer Paul Nyamudi, representing the third petitioner Youth Advocacy Africa, informed the Supreme Court judges that IEBC Chairman Wafula Chebukati created a non-existent position of returning officer in the commission to give himself exclusive powers.
Those two regulations are inconsistent with the provisions of Article 138(3)(c) of the Constitution, because they enable the result in the presidential election to be verified and tallied in a manner other than envisaged by the Constitution.
Appearing for the fourth petitioners, Khalif Khalifa, Jojo Sowe, Ruth Mumbi and Grace Kamau, lawyer Willis Otieno urged the Apex Court to invalidate the election of President-elect William Ruto, since IBC Chair Wafula Chebukati erred in excluding the other four commissioners.
At the end of the day, when you leave, are you able to answer the constitutional threshold, the question, is that system of technology simple, verifiable, and accurate? Why the many explanations? Why the kizungu mingi?
Also challenging the presidential election results is petitioner David Kariuki, who claimed that the results declared by IEBC Chairman Wafula Chebukati on August 15 did not reflect the will of Kenyans.
We know that it's only elders where elections were taking place.
Another petitioner, Busia Senator-elect Okiya Omtata, urged that there were numerous mathematical errors in the presidential tally and that 140,138 votes were untallied.
No candidate acquires 50% plus one vote. You get that William Ruto gets 49.999692402%. So Raila gets 48.372118662.
The Independent Electoral and Boundaries Commission, dissenting 4 commissioners, poked holes on the presidential results released on 15th August by the commission's chairperson Wafula Chebukati. Lawyers Paul Muite and Issa Mansour, representing IEBC Vice Chairperson Juliana Cherera, Justus Nyang'aya, Francis Wanderi and Irene Masit, claimed Chebukati excluded 4 commissioners in the constitutional process, only assigning them protocol roles.
Under the Constitution, and in fact under the statute, the IEBC is a corporate entity. Therefore, in the absence of consensus, its decisions as an institution are by the majority.
The 27 constituencies that had not been announced had not been publicly confirmed to have been verified.
The second day of the Supreme Court hearing saw the Independent Electoral and Boundaries Commission Chairman Wafula Chebukati, 2 commissioners Molu Boya, Professor Abdi Gulie, and Chief Executive Officer Hussein Marjan disregarding affidavits by 4 dissenting commissioners.
It will be absurd to say that the only verification that is acceptable under the law is verification by the commissioners. What then would we make of the elections at the counties and the tallying and verification at the counties and the tallying and verification at the constituencies where no commissioner is present?
There is something very wrong in the way the persons who participate in the electoral process accept winning or losing. That's the problem.
On the same day, President-elect William Ruto's defense team, led by Senior Counsel Fred Ngatia, urged the Supreme Court judges to dismiss the presidential petition, terming it fictional.
Show us one Form 34A in the public portal, because that is where ultimately it landed, which differs with the hard copy at the polling station. Show us only one. Or show us a ballot box that people from outer space came, voted into, stuffed into it, and then all this hijacking in midair took place. There's no such evidence.
In our humble and respectful view, Chief Justice, my lords, my ladies, the events of that day are basically an attempted but failed coup d'etat.
On his part, Attorney General Kithure Kindiki, through his lawyer George Oraro, while making his submissions, told the Supreme Court that the visit by members of the National Security Council to the IEBC was not to intimidate the commissioners.
He was sending a team to go and visit him and discuss the issue of security. That notwithstanding, the chairman pretends that this was an issue which he only came to know when he was informed by Professor Gulia.
The 3-day hearing at the Supreme Court came to a close on Friday, with lawyers representing Raila Odinga and other petitioners clashing with those of the IEBC during oral submissions based on a 178-page report by the Registrar of the Supreme Court on the ICT scrutiny, inspection, tallying and recount.
At the material time, foreigners, including Ogodino, Vito, J. Carmago, Josio were operating the system.
Compare the logs Mr. Mugo has provided and what is found in the registrar. You will discover there is an apparent discrepancy on the face of those logs. Nothing put on the slideshow is in the registrar's report.
Ben Chumba, Sunday Express.